Welcome to Module number 6. What about other human subject protections? If you are having trouble accessing any of these modules, contact the Chief Privacy Officer at privacy@uvm.edu or call the Office of Audit, Compliance, and Privacy Services at 802-656-3086. Otherwise, let's begin. Much of your research that requires the access or use of PHI is going to be governed by either the Federal Policy for the Protection of Human Subjects, which is also known as the Common Rule, or the Food and Drug Administration or FDA's Protection of Human Subjects regulations, or both. The FDA also has additional human subject protection regulations, which apply to research involving products regulated by the FDA. Lastly, certain federal agencies, such as NIH, CDC, FDA, and others, may grant researchers certificates of confidentiality designed to protect researchers and institutions from forced disclosure of research records. The Common Rule is intended to protect the rights and welfare of human subjects involved in research conducted or supported by the Department of Health and Human Services. The FDA Protection of Human Subject regulations are intended to protect the rights, safety, and welfare of participants involved in studies subject to FDA jurisdiction. Although these human subject regulatory requirements, which apply to mostly federally funded research and to some privately funded research, include protections to help ensure the privacy of subjects and the confidentiality of information, the intent of HIPAA's privacy rule, among other things, is to supplement these protections. The privacy rule does this by requiring covered entities to implement specific measures to safeguard the privacy of individually identifiable health information. The privacy rule does not replace or act in lieu of these human subject protection regulations. This means that some researchers who are themselves a covered entity or who otherwise work for a covered entity may find themselves responsible for complying with multiple sets of regulations. To the extent that a covered entity is also a federally assisted drug abuse program, the covered entity is also subject to the confidentiality of alcohol and drug abuse patient records regulation. It may therefore be necessary for covered entities to properly use and disclose individually identifiable health information in compliance with both sets of regulations. If your research involves records from a federally assisted drug abuse program, you should also review the materials provided on Substance Abuse and Mental Health Administration's website, which can be found at www.hipaa.samhsa.gov. Then there are certificates of confidentiality. These certificates offer an important protection for the privacy of research study participants by protecting identifiable research information from forced disclosure, such as through a subpoena or court order. The certificates allow investigators and others with access to research records to refuse to disclose information that could identify research participants in any civil, criminal, administrative, legislative, or other proceeding, whether at the federal, state, or local level. As stated earlier, certificates of confidentiality may only be granted by the National Institutes of Health, the Centers for Disease Control and Prevention, the Federal Drug Administration, and other federal agencies. By protecting researchers and institutions from forced disclosure of such information, certificates of confidentiality help achieve research objectives and promote participation in research studies. The privacy rule and certificates of confidentiality afford distinct privacy protections for research subjects. For example, the privacy rule does not protect against all forced disclosure since it permits disclosures required by law. On the other hand, certificates of confidentiality are legal protections that do protect against forced disclosure by giving their holders a legal basis for refusing to disclose information. Absent the certificate of confidentiality, researchers would be obligated to disclose this information. So what does this all mean? It means that while all of these federal and state regulations relate to privacy, their overall objectives and applicability varies. The overall objective of HIPAA is to establish a federal floor of privacy protections for most individually identifiable health information by establishing conditions for its use and disclosure by certain healthcare providers, health plans, and healthcare clearinghouses. The Common Rule, on the other hand, is designed to protect the rights and welfare of human subjects involved in research conducted or supported by the Department of Health and Human Services. It is not specifically a privacy regulation. The FDA's Protection of Human Subjects objective is to protect the rights, safety, and welfare of subjects involved in clinical investigations regulated by the FDA. This also is not specifically a privacy regulation. HIPAA applies to covered entities regardless of funding. The Common Rule, on the other hand, applies to human subjects research conducted or supported only by the Department of Health and Human Services, and the FDA protections apply to research involving products regulated by the FDA. However, federal support is not necessary for these regulations to be applicable. UVM extends these protections beyond that which is supported by the Department of Health and Human Services. In other words, funding is irrelevant in this regard. UVM applies the Common Rule protections regardless of who is funding the research. When the research involves products regulated by the FDA, and the research is also supported by the Department of Health and Human Services, both the Common Rule and the FDA Protection of Human Subject regulations will apply. You have now reached the end of Module number 6. If you are taking this training as part of a requirement, you will have to answer some questions in order to move on. Next up is Module number 7. How does the privacy rule apply to research?